Welcome to Advisory Opinions. I'm Sarah Isgur, and David French is doing some nonsense with his other employer today, which is great that I have the extended universe now. So we've got David Latt from Original Jurisdiction and Amy Howe from SCOTUSblog joining us. We will walk through the arguments in that St. Isidore Religious Charter School case, then a little maybe circuit update world from David Latt, and finally, some May 15th preview on the arguments we're going to hear about nationwide injunctions, associational standing, birthright citizenship. Is that a thing? What happened to that 14th Amendment? So I'm just going to run through what David and Amy are looking for in that case. Okay, we're going to start with the St. Isidore oral argument. This was the case about religious public charter schools. David French and I talked about it on the last episode and really set up the facts and some of the law on this. So if you want a deeper dive about how we got here, check that out. But in short, St. Isidore is a online Catholic school. They wanted to be a charter school for Oklahoma. They applied to be a charter school. The charter school board granted them the charter to be a public charter school as a religious public charter school that would, teach Catholic stuff. So the legal question in this case is really, Oklahoma labels all charter schools public schools, but is this a public school or a private public school? All turning around this idea of state action doctrine. Is this a government actor, in which case you would have establishment clause problems if you're teaching Catholic doctrine? Or is it a private actor getting a public benefit, the charter, in which case you would actually be violating the free exercise clause if you deny them the charter because of their religious status. So here's the interesting part. Justice Barrett has recused herself from hearing this case, meaning we only have 8 justices. Now, if it ties 4-4, the charter school loses. The state of Oklahoma, represented by the Republican Attorney General, doesn't want this charter school. They think it violates the Oklahoma Constitution. So a 4-4 is a loss for the religious charter school, a win for the state of Oklahoma. If you're the charter school, you've got to count to 5, like usual. If you're the state, however, you only have to count to 4. That's what makes the recusal interesting, is that basically one side only needs one fewer vote. Okay, so Amy, you were in the courtroom. What did you think?
And so, we don't know exactly why Justice Barrett recused herself. Sometimes some of the justices will, explain at least sort of cryptically why they are recusing themselves with references to prior judicial service. Justice Ketanji Brown Jackson has included that a couple of times. Prior government service, Justice Kagan referring to her time as the Solicitor General, which seems kind of remarkable considering how long she's been on the Supreme Court. But we don't know exactly why. The one set of the parties in this case was represented by the Notre Dame Religious Liberty Clinic, and Justice Barrett was a professor at Notre Dame Law School for a long time before becoming a federal judge on the Seventh Circuit, and one of the leading advocates, one of the scholars sort of advancing the idea that public funds should be available for religious schools, is a law professor at Notre Dame named Nicole Stell Garnett, who is a very close friend of Justice Barrett. So from the get-go, she was recused. We don't know why. And so, that means effectively that, if you think of this as the liberal justices against the conservative justices, that the liberal justices just need to pick up one more vote. It seemed pretty clear pretty early on that vote was not going to be Justice Brett Kavanaugh. So, it really seemed like the most likely vote was going to be the Chief Justice, John Roberts. And at the beginning of the argument, he had questions, and pretty early, particularly at the beginning of his tenure, it seemed like he was the justice who was most likely to be the sort of devil's advocate justice. He'd ask questions on both sides, and he doesn't seem to do that as much these days, which I find kind of curious that he has been less likely to do it now that the time for arguments has sort of expanded infinitely. It's not like he doesn't have time to do it. But, he did at least seem to be doing it during this argument. He had questions for James Campbell, who was representing the school board. There are three sort of sets of three cases. We'll call them the Trinity Lutheran Trinity, so to speak, or the Trinity Lutheran trio of cases that the school board and the charter school itself were relying on, a case called Trinity Lutheran versus Comer, involving program to provide funding to resurface playgrounds at school, a case called Espinoza versus Montana Department of Revenue, involving tax credits for scholarships, whether or not they could be used at private religious schools in Montana, and then a case called Carson versus Macon, involving Maine's use of public funds for private schools. And he said, to James Campbell, he said, those involved fairly discrete state involvement, and this does strike me as a much more comprehensive involvement. And then when he was talking to John Sauer, the new Solicitor General, he had questions about, whether or not the state can impose requirements on charter schools, like do they have to teach Oklahoma state history, and whether or not the extent of that state involvement affects the analysis about whether or not these are public schools or state actors. But then he also had some pretty tough questions for Greg Garr, the lawyer representing the Republican Attorney General, who was opposed to having St. Isidore, the Catholic virtual charter school, being a public charter school. And Greg Garr is a former Solicitor General during the George W. Bush administration. So, Roberts clearly seemed to me to be the key vote. I think most people coming out of the oral argument expected him to vote with the other conservative justices, but, we'll see by the end of June, beginning of July.
David Latt, do you agree that the chief is the swing vote?
Yes, absolutely. I think that his vote is critical. And it's interesting. You have talked with David before about how this term is sort of a lower temperature term than in the past. And so I don't know if the chief is going to be as worried about causing a ruckus with this particular case. I think he's very sensitive to the institutional issues and standing of the court and how it spends its political capital. But here, I think this is kind of like, I guess if we were on Capitol Hill, this is kind of like a free vote. I think he can kind of vote as he wishes. And in the past, he has voted to protect the rights of the religious parties. He actually wrote the opinion of the court in one of the cases Amy just mentioned, the case out of Maine, the Carson v. Macon case. But it was interesting. One line in that opinion from Carson by the chief that recurred in this argument was, there is an argument there where there's a statement in Carson where the chief said that Maine can set up, quote, strictly secular, close quote, education if it wishes. So it's interesting. This is definitely going to be moving the ball forward for religious education, in the sense that I do think, as some of the liberal justices were saying, and as Chief Justice Roberts suggested with one of his early questions, I do think this is an extension of existing doctrine. I don't think it's squarely controlled by that trinity of Trinity Lutheran cases that Amy mentioned.
Well, and the Trinity Lutheran, he also wrote the Trinity Lutheran case. And this is really sort of digressing into like inside baseball nerdery. That was another one, like when it came out, like, he has a footnote in that case. It was like, this case is only about playground resurfacing. That was a 7-2 case, in which Justice Kagan joined the full opinion and Justice Breyer was concurring. And that was a really weird one because, now we're really going to go down the inside baseball lane. Like, that was a case that was granted in January of 2016. And like, you remember who was on the court in January of 2016? Like, that was granted while Justice Scalia was still alive. And then he died. And as many of your listeners may remember, they only had 8 justices for a long time. And so that case was not argued until April of 2017, which was highly unusual. They were like holding it for Gorsuch because I think they were worried about the possibility of a tie vote. And then it turned out to be kind of a nothing burger, at least in terms of the court being divided. It was 7-2. But, it didn't seem to be imbued with the sort of force that it then acquired as part of the Trinity.
So there's a case you guys haven't mentioned yet, which I feel like far more controls the Chief's vote than the Trinity, which is Fulton. Also
Yes.
written by the Chief Justice. Fulton, for you guys who maybe don't have this at the tip of your brain, that's the case about the Catholic charities providing foster care service in Philadelphia. And Philadelphia did basically refusing to renew their contract to provide foster placement services because they wouldn't certify placements with same-sex couples. Here's just a few little lines from the Chief Justice from that opinion. The government fails to act neutrally when it proceeds in a manner intolerant of religious beliefs or restricts practices because of their religious nature. The refusal of Philadelphia to contract with Catholic charities for the provision of foster care services, unless it agrees to certify same-sex couples as foster parents, cannot survive strict scrutiny and violates the First Amendment. So, Amy, when you mentioned the chief asking questions of Greg Garr, who represented the Republican Attorney General, remember the state here, the very conservative state, doesn't want this religious charter school. It's a little bit confusing if you're used to these very clear ideological / partisan valences. This is some right-on-right violence. So he says, why doesn't Fulton control this?
Right.
And I thought that was interesting because really in the other questions the chief was asking to the other 2 advocates, they felt a little bit like, well, I'm starting this, so I might as well ask a question.
Right.
With Garr, he actually seemed to follow up more and was like, yeah, but Fulton, am I right?
Right.
So I feel like because we have the chief, you almost see, as David, as you said, it's an extension, certainly. It's not controlled by any previous cases, but it keeps extending. So Trinity is supposed to be just about playground rubber resurfacing. It can't be about cement resurfacing or mulch resurfacing, right? It's only used tire resurfacing for playgrounds. And then it keeps extending with the chief continuing to write all the way up through Fulton, which is limited in its scope in some other ways, but not limited in the chief believing that if you have this thing you're doing as the government and giving it to private actors, and inviting them in to what would otherwise be a public service, like foster care, like education potentially, I feel like he's saying, look, at minimum, strict scrutiny applies here, meaning you've got to have a compelling interest, providing secular education, okay? And then it's got to be narrowly tailored. But in this case, of course, there are traditional public schools that are government run in Oklahoma. Now in a different state, New Orleans, as I understand it, has almost exclusively charter schools at this point. Maybe you could survive strict scrutiny in that state because your compelling government interest providing a secular education cannot be met if all of the charter schools suddenly become religious. But I felt like I counted to 5 here. I feel like the chief is a pretty solid vote on the side of St. Isidore. I was surprised, and I'm curious to get y'all's reaction to this. I was surprised with some of the ferocity of Justice Kavanaugh, our traditional swing vote in some ways. He was not a swing vote at this oral argument by any stretch of the imagination. And this exchange with Justice Alito, also very clearly on the St. Isidore side, about a masterpiece cake shop problem. And remember, masterpiece cake shop is whether you have to make the cake for a same-sex couple or whether that violates the public accommodation laws. We're all teed up to get what would end up being the 303 creative decision. But a masterpiece cake shop, they don't decide on the merits. They really say, look, the Colorado board was so hostile to religion and showed so much religious animus. We don't even really need to get to the underlying legal merits because this itself was a legal violation. So you have Justice Alito saying, didn't the Oklahoma Attorney General, Greg Garr's client here, show that same kind of animus? He read the quote from him. This is the quote. While many Oklahomans undoubtedly support charter schools sponsored by various Christian faiths, the precedent created by approval of the application will compel approval of similar applications by all faiths. I doubt most Oklahomans would want their tax dollars to fund a religious school whose tenets are diametrically opposed to their own. And Justice Alito says, isn't that a very serious masterpiece cake shop problem? The whole position that you're defending seems to be motivated by hostility toward particular religions. And he goes on, here we have a statement after statement by the Attorney General that reeks of hostility towards Islam. And then we have the provision of the Oklahoma Constitution on which the Oklahoma Supreme Court relied that has its own unsavory discriminatory history. He's referring, of course, to the anti-Catholic Blaine amendments that swept the country at one point. David, I'm curious what you thought of the masterpiece cake shop part. No other justice picked up on it, but I'm wondering if we feel an Alito concurrence.
I could definitely see that because he has written over the years a number of concurrences where he laments what he feels is an increasing hostility to religion and religious people and branding them as bigots, etc. But I actually don't really agree with that point. If you look at the record in Masterpiece Cake Shop, which was about the baker who didn't want to bake the cake for the same-sex marriage celebration, the board there has a lot of stuff that basically involves them looking down their nose at religious people. The comment by the Republican Attorney General here, Gentner Drummond, I think he was merely stating, look, as a logical matter, if we allow these religious charter schools, you can't just have your favored religion, which for the majority of Oklahomans is some kind of Christian faith. You could end up with, and I think the examples he gave were Wicca or Wiccan, or I don't know what the, Wicca, whatever, Sharia law. He's really just explaining the logical implications. I don't think he was saying, I, Gentner Drummond, personally have a problem with, he probably does have problems with Wicca or whatever, but I don't think he was saying, I personally am hostile to these things. I think he's just saying, look, people of Oklahoma, if you allow this school because you like Catholicism or Christianity, you have to understand that that rule applies to all faiths. You can't sort of have your Catholic wafer and eat it too. You have to understand that this is a principle you're establishing. You're not just thinking, do we like Saint Isidore?
All right, Amy, my question for you is about semantics here, because a lot of this is going to turn around, well, according to the state, the Attorney General, this is about, the state of Oklahoma has already defined this. To become a charter school is to become a public charter school. Therefore, it's a public school. Therefore, it must be secular. Why are we even here? And the St. Isidore side says, yeah, we're a public charter school. But the word public doesn't mean what you say it means. It actually is a private public charter school. We basically just keep adding words on to get to where each side wants to be.
We're taking your money, but we're not public.
But we're not you.
We're not government.
We're not government actors just because you label us a public school. And a couple things came to mind here. One, this was also a labeling issue in Fulton, right? Because the city of Philadelphia labeled foster care service a public accommodation. And you do have this section in the opinion by the chief that's labeling it a public accommodation doesn't make it a public accommodation. It's not like a hotel. There's a huge amount of discretion involved in who gets to be a foster parent. That's very unlike a hotel where we basically say everyone gets to stay here except you because I don't like you, based on this, immutable characteristic. That's what public accommodation laws are for. So you can't just label things so that you can exclude people. That again it feels decisive for me for the chief. I'm curious what you think of the semantics issue. And second, the Attorney General's argument basically said St. Isidore doesn't exist as a separate entity. It only exists once we gave them the charter. And that they really kept going back to that argument over and over again, except that would be true of corporations. The state gives you your corporate charter. You're not incorporated until the state says so, right? And so I was sort of curious what your reaction, Amy, was to the St. Isidore doesn't exist until it gets the charter, therefore it is an arm of the government, and why that wouldn't apply to corporations?
Yeah, I mean, I'm not sure about that one. I mean, I think that you're right about the semantics, because that's really what the whole case hinges on, is whether or not it's either a state actor or a government entity. And so, like, just sort of slapping the public label on it isn't going to do the trick. One of the things that that Greg Garr was, he managed in the Fisher case twice to sort of snatch victory from the jaws of defeat.
Fisher is the affirmative action
Fisher
case
versus University of Texas. So two cases challenging the University of Texas's consideration of race in its admissions programs. And this was before the Harvard and University of North Carolina affirmative action cases. And they, efforts by the same sort of people who brought the Students for Fair Admissions case against Harvard and North Carolina, but just earlier and with a different court. And so they hired Greg Garr to defend the program successfully twice. And, one of the things that he was also sort of working against was the argument by the charter school board and the charter school that if St. Isidore's were a public entity or a state actor, that it might make all these other faith-based services state actors and could create real problems there. And he was, trying to differentiate those. And, I think had some good arguments, but again, not sure that there were 5 votes for it, or even 4.
What about my concern that I mentioned on the last episode, that this is not legally relevant in a lot of ways unless you're a consequentialist type, y-axis super institutionalist judge. But nevertheless, I want to ask you guys, because I am a big First Amendment fan, but I don't actually care myself about religious charter schools. That's not something on my bingo card that I'm like, oh, the country really needs this to fulfill its manifest destiny or something. But I do really care about school choice. And my concern is that there will be a rule in this case, if I'm right, that the Chief Justice makes 5, that will provide a lot of fodder to the anti-school choice movement. Because basically, if you have a relatively traditional school choice program, the whole point of which is to have schools not run by the government, but run by people who are willing to try creative new ideas, and all of a sudden that means you must include religious schools and all religious schools, that both from the right and the left, you could end up squeezing out school choice in a lot of cases. As the Attorney General mentioned, is Oklahoma really going to keep this program when you have some, yeshivas and Muslim schools popping up, or Wiccan charter schools popping up? I don't know. And on the flip side, if you're in a very blue liberal state that has a strong teachers union, you just handed them a giant cudgel to be like, oh, see, we can't have school choice anymore, or else all of these schools are going to be run by religious right-wing wackos. And now we just killed school choice. And it's a totally Pyrrhic victory for St. Isidore, because in 20 years, there won't be any charter schools, St. Isidore's or otherwise. David, is my concern crazy?
No, I would call it a shirtlift problem. Shirtlift is the case about the flags in front of Boston City Hall. And they wanted to raise a Christian flag. And then the Satanists came along and said, well, what about the Satanist flag? And finally, they ended up with a sort of, this is why we can't have nice things solution, where they said, okay, only the Massachusetts or the Boston flags will fly. So here, I agree with you. I share your concern. If we are now suddenly going to see applications for charter schools from Wiccans, some schools may say, some states may say, we're not going to have charter schools at all. And remember, nobody is denying the power of a state to say no charter schools. even the conservatives. If a school wants public education to be administered strictly by public schools, that can be done. And I believe there are something like 46 states that have charter schools, but that means there are 4 that do not. And so you could end up rolling back charter schools and school choice with a situation like this with an overly broad ruling. So I totally share your concern. Going back to your earlier point about the corporations, I guess I'm sympathetic to that argument in this sense. What they're trying to say is, look, St. Isidore has not opened its doors or its portal if it's an online school, in the sense that it is a creation of this Oklahoma statewide charter school board and Catholic entities, whether it's the Archdiocese of Oklahoma or the Diocese of Tulsa. Now, with a corporation, say I have my little Schedule C business, Lat Legal LLC or whatever, fine, I have recognition from the state of New Jersey. But even before I got that recognition, I had my little business and I have my newsletter and speaking and freelance writing, and I run it, I was doing my thing before I got recognition from the state of New Jersey as an LLC. St. Isidore hasn't done anything. It hasn't educated a single student. It is created by the Archdiocese, the diocese, and this board. And remember, it's kind of weird. You talked at the beginning about the sort of strange bedfellows thing here. The alliance here is St. Isidore, represented by Mike McGinley of Deckert, and the Oklahoma statewide charter school board, represented by the Alliance Defending Freedom, or ADF. But that board is a public entity. So you basically have a public entity and a private entity litigating against a public entity, namely Oklahoma, represented by Greg Garr and Latham and Watkins. So it is, I think, I'm very sympathetic to Garr's argument. People kept pressing him at argument, hey, why is this different from the Trinity case? And he said, look, this, unlike those other things, this is a public school. This is created by a public charter. This is created in part by a government entity, the Oklahoma statewide charter school board. So I'm very sympathetic to that argument. I do think this is different from the Trinity.
And I think he also said, that the money goes directly from the government to the religious institution, in. Yeah. So, the other sort of strange bedfellows sort of, you sketched out on the one hand, you had the the charter school board and the virtual charter school on one side against the state's Republican attorney general. On the same side, not arguing, but sort of as amicus briefs on as the state's Republican attorney general, perhaps for the first and last time, you had the teachers unions and the charter schools, who hate each other, like with the fire of 1,000 suns.
Well, speaking of switching sides, Amy, also an interesting moment in the argument where Sotomayor asks the Solicitor General basically why the administration has changed positions, and then doesn't wait for him to answer, and then says, yes, because the administration has changed. Look, on the one hand, I thought that was kind of this like odd, snarky moment that was unnecessary. Like, was she saying that during the Biden administration to Elizabeth Prelogar when Elizabeth was changing positions for the Solicitor General's office?
No, on the other hand, somebody else was.
Yeah, fair enough, actually. Well, I don't remember. Maybe I don't remember, Amy. Maybe you remember better. The sort of just snark attached to it felt a little uncharacteristic.
I'll take a look before the next time. Come on.
I'm curious. But my question to you is actually, do you feel like we're seeing more switches from the Solicitor General's office? It used to be a point of real pride that they would not change positions in cases. Their consistency was part of their legitimacy, part of what made the Solicitor General the 10th justice and gave them so much credibility in front of the court. We've talked in other contexts where that presumption of regularity is draining quite quickly from the Solicitor General's office in how the justices are treating this administration. And that can certainly be from the litigation positions of this administration. But I also wonder whether it has happened over time, a slower erosion of simply flip-flopping where the Solicitor General's office comes in on these cases.
Yeah, I mean, I think we tend to think of the Solicitor General switching sides in like a particular case that's currently before the court. When the Solicitor General, after the inauguration, came to the Supreme Court and said, there are these cases that you're going to hear on the merits, and we're reconsidering our position. We'd like to push them back. And, so at least one of them, I think, is on hold. There are a couple of them where the other side was like, no, actually, we'd like to go ahead with the argument. And so they did hear argument. But then there's some like Scrimeti where they switch their side, United States versus Scrimeti, the challenge to Tennessee's ban on gender affirming care for minors, where they switch sides after the argument. It's just sort of like, we're letting you know that. But then there are these other issues, that sort of bubble up. And this was, I can't remember, it was the government's position in an amicus brief in a case involving a dress code at charter schools. It was a charter school in North Carolina where the female students were required to wear skirts or dresses to school. And the Biden administration was like, I don't think so. And so this is, took the position that they were public entities, I guess. And
right.
So the Solicitor General, obviously in this case was taking the opposite position.
Well, it'll be interesting. All right, we'll put a pin in that until the opinion comes out. David Latt, your newsletter this week highlighted a few interesting circuit decisions. We're not going to spend a lot of time on them, but I just thought you could give us a tour of what's going on in the circuit courts these days, because AO has not gotten into the circuit level in a few weeks, and I'm feeling, sort of like when you eat a whole bunch of steak, but there's no side dishes. I'm longing for some carbs,
Well, I think one issue is you mentioned a few interesting circuit decisions, emphasis on a few. I feel that lately there have been fewer notable circuit court decisions. I go to Short Circuit by John Ross and Howe Appealing by Howard Bashman to check out what's going on in the circuit courts, in addition to what I hear from readers in terms of readers who flag opinions for me. And I don't know if judges are holding back on issuing opinions in the circuit courts that they want to get noticed because they're competing with everything in the news cycle, or whether the circuits themselves are so busy with Trump stuff, because the circuits have their own version of the shadow or emergency or equity docket, whatever you want to call it. The DC Circuit, for example, has this special panel which sits for a month and hears requests for emergency relief. And they actually had a pretty interesting case recently, the National Treasury Employees Union v. Vaught, where there was the issue of whether or not to allow layoffs at the Consumer Financial Protection Bureau, or CFPB, to proceed, while the merits case in the DC Circuit goes forward, or whether to put those on hold until the DC Circuit gets to hear the merits there. And there you had a split between two notable conservative Trump appointees. Judge Katsas said, let's put it on hold. He joined with Judge Pillard, who's a pretty liberal Obama appointee. And Judge Rao said, no, let the layoffs fly. So I think the circuit courts are kind of busy too. I guess I can mention a couple. One that was sort of interesting is this United States v. Chattery case out of the Fourth Circuit. It's about the constitutionality of geofence warrants, which are these warrants where you tell law enforcement to search a database to find all mobile devices within a specific geographical area and time frame. So they're not as targeted as normal warrants. And so there are questions about their constitutionality. So the Fourth Circuit goes en banc, meaning that all the judges hear the case, not just a panel of three. But basically, there is one sentence that is precedential there. The judgment of the district court is affirmed. And then you had a gazillion concurrences, more than 120 pages of opinions, which, as John Ross pointed out, is longer than Heart of Darkness, the novel. And you didn't really get anything out of it. But, that's a situation where the Supreme Court's going to weigh in soon, I think. The Fifth Circuit had its own geofence opinion. Professor Oren Kerr, friend of the pod, has been writing a lot about this issue. So I'm not getting hugely worked up about that because I think SCOTUS is going to step in before too long. But, that's one case. Another case that I mentioned in original jurisdiction was this United States v. Bricker case out of the Sixth Circuit. This is about the First Step Act, which allows judges to essentially change the sentence of somebody they previously sentenced, sometimes years after the original sentence, which you really weren't able to do until the First Step Act, which was actually a criminal justice reform that happened during the first Trump administration. And so there's a question about whether, if the law changes, a non-retroactive change in the law, that means that some defendant who got sentenced to something really harsh would have gotten a lower sentence under the new law. Is that a ground for a sentence reduction under the First Step Act? And there, the Sixth Circuit, pointing to a prior Sixth Circuit ruling saying no, said it is not a permissible ground for changing a sentence, even though the Sentencing Commission, the administrative body, had said yes. And essentially, it kind of became a separation of powers thing, because Judge Alice Batchelder, who wrote the majority opinion, said that this policy statement of the Sentencing Commission is plainly unreasonable under the statute and in conflict with the separation of powers. So it's kind of also a Loper-Bright sort of issue, in the sense that if we're not going to defer to any kind of agency like the Sentencing Commission, then a judicial decision saying you can't do this under the First Step Act, that kind of is the last word. So those are a couple of decisions that I mentioned. There are also some from a few weeks back, but perhaps you or Amy have thoughts on those.
I have a question for you about this, Amy. So let's assume for a moment, and I'm not saying that's true, but that the circuit judges are being strategic in when they release opinions. And next fact that I want you to assume in our world, but this one's true. The long conference, basically, if you file a cert petition over the summer, the justices will not consider it until that first conference of the new term, OT25, called the long conference. And statistically, you are less likely to get your cert petition granted at the long conference.
Right.
Now, it's sort of weird, because on the one hand, it's also when the most cert petitions get granted. But your percentage
it's still statistically
chance,
much lower.
Much lower. Okay. So if you're a circuit judge and you want your case to get taken by the Supreme Court, you need to hurry, because you're running out of time for them to actually grant cert. If you're a circuit judge that doesn't want your case to get overturned by the Supreme Court, for instance, then you want to hold it to make sure it goes up in the summer to get to the long conference?
I mean, I think that if you are a circuit judge, you know that there are so many other factors that are out of your control. Like, I suppose it depends on what the practice is in your circuit of like how often people seek rehearing or rehearing en banc. And then, everybody at this, like, there used to be a thing in the Fifth Circuit where Justice Scalia never gave extensions to file your cert petition. So, like, coming out of the Fifth Circuit, you knew, like, you were going to have to file your cert petition in 90 days, come hell or high water. But I think everybody will give at least one extension these days. And I think most people will give two. So you're looking at like 90 days plus another 2 months until the cert petition gets filed. If somebody wants to try, if you're dealing with a savvy Supreme Court advocate who wants to try and push it past the long conference, and then the possibility that whoever is the respondent, if they are savvy, can do the 30 days to respond plus another 1 or 2 extensions. And so trying to time your Supreme Court cert petition, like, unless you really want to get tricky, like, and file right away and then like be a real, I'm not sure I can say this,
jerk.
Be a jerk. In terms of
this is a family-friendly show, Amy Howe.
Rejecting requests for extensions from your, I hate the term friend on the other side, your adversary. There's at the time, it's hard to time.
Okay, so there's no strategy, David?
I would agree that there isn't really a strategy, in the sense that if you're a circuit judge, I do think that they might decide, okay, you know what, this was a hectic news week. I don't want this to get lost in the shuffle. I'm going to hold it till next week. But in terms of a circuit judge wanting their case to get granted, I think, and I'm going to kind of congratulate present company here, I think there's less of a concern about cert-worthy cases getting overlooked, because there's a lot more coverage of them than there used to be. They hear about these cases on Advisory Opinions and SCOTUSblog and Original Jurisdiction. And if you have a good, juicy, cert-worthy case, I think it's less likely to get lost in the shuffle because clerks and maybe even justices are reading newsletters and listening to podcasts and saying, oh, that's an interesting case about geofence warrants, and there's a big circuit split on that. I think we should get on that. So I think that if you have a really cert-worthy case, your chances of getting it granted in a day and age where there's so much more coverage of the lower courts, I wouldn't worry too much about it because they'll get to it.
Yeah. I mean, I could if you really want to get attention, you can write some snazzy, especially if you are in dissent, write a snazzy dissent. The other thing you do, if there's a genuine circuit split and you want, just put a little header that says the circuit split. One of the cases, one of the cases I argued had a header in the lower court opinion that said the circuit split. And so when I went to call
grant cert here,
the lawyer in the lower court, we were the third clinic to call them.
Yeah, I mean, and this gets, by the way, for our non-lawyer, non-Supreme Court advocate lawyer listeners, right? There's square circuit splits. I would define a square split as where the circuit judge writing actually acknowledged the circuit split, for instance. That to me is a square one. But really what it means is it's a true split on a real question of law. And then on the other end of the spectrum are the manufactured circuit splits, where they're well, if the case is decided on a Tuesday after 4 p.m., the Fifth Circuit went this way, but the Ninth Circuit went this way. And everyone's kind of oh, I'm sorry, that's not real. But anything to get that circuit split for your cert petition. Okay, I've got another question, David. This one's on the Fourth Circuit case that you mentioned in the Heart of Darkness. Do you feel like the lower courts, particularly sitting en banc, but there's certainly examples where it's not just that, are writing more and more concurrences and concurrals and dissentals? That's when it hasn't even been taken en banc, but they're writing about whether it was taken en banc or not taken en banc, as it were. Do you think that is leading or following the Supreme Court trend? Because there's certainly more separate writings at the Supreme Court, which, again, on that institutionalist axis that I like talking about, is very low institutional behavior. You are not acting as an institutionalist if you're writing in your own voice and really feel like the world needs to hear your thoughts on this case, whatever those thoughts may be. But one more thing. So I feel that I'm seeing more of that behavior from the circuit courts, but I don't know whether it's leading or following or whether it's just everyone having extra time on their hands. But I remember when concurrals and dissentals were suspect, people weren't sure if they even should be a thing. We're way past that world now.
Yeah, no, I think it is both following and driving. There may be whether you like this trend of separate opinions or not, there may be a virtuous or a vicious cycle going on. Certainly the Supreme Court justices are, in a sense, modeling opinion for the circuit judges. And so if the circuit judges see lots of separate writings, some one paragraph thing by Justice Jackson, they'll say, hey, well, why shouldn't I do that? The other the contributing factor I would mention is I think also some circuit judges see these separate opinions as an opportunity to, quote unquote, audition for a Supreme Court seat, where they essentially say, hey, look at me. I have really conservative views or really progressive views or really interesting theories, and that helps put me on the map. So, for example, it wasn't really as much of a thing back then because he's been on the court for a while now, but Justice Gorsuch, when he was being considered as a potential nominee, jumped out to people on the conservative side of things or the right side of the aisle because he had written a series of separate opinions about Chevron, which was a kind of bugaboo of the conservatives. And so it works, I think. The strategy works in terms of writing separate opinions that get you noticed.
I think it does, but I will say what made Gorsuch stand out was that he was writing in a pre-filibuster, as in there was still the filibuster. So it made him particularly brave, if you will, to speak out on issues when, at the time, it looked like you would need to be confirmed by members of the other team. Now, without the filibuster, I think we're seeing a lot more auditioning behavior, or at least the barriers to auditioning behavior or the risk of auditioning behavior is basically at zero. Because if the president of your side and the Senate is controlled by that president's party, you don't need any votes from the other side because the filibuster's gone. Something I have decried as, I think, really changing which types of people want to be judges, what they act like when they become lower court judges. And I think we're just at the very beginning of that behavioral shift, because we still have by far a majority of justices and judges who came in during filibuster behavior time. And you're not going to see the switch, like a light switch, when the filibuster goes away. They're just starting to realize, the velociraptors are realizing that the electric fence doesn't work anymore. But does it work over there? I don't know. Does it work over there? It's going to take them a minute to just totally break out of the pen. But I totally take your point that at least some of this proliferation of separate opinions and concurrences is probably driven by the end of the filibuster, would be my argument. Amy, thoughts?
Yeah, I mean, that all sounds right. And, again, it's like another way to sort of link back to the idea of if you want the court to take up a case, it is another way to get the court's attention.
Okay, I want to talk about the May 15th birthright citizenship argument that won't be about birthright citizenship, except it might be. This is President Trump's one of his first executive orders, which, for all intents and purposes, ended birthright citizenship. So Section 1 of the executive order identifies two circumstances in which a person born in the United States is not subject to its jurisdiction. And remember, that's really relevant because of the 14th Amendment's language. Well, let's even back up from there, right? Dred Scott, really bad decision, says that Black people, slave or free, can never be citizens of the United States. We fight a civil war. It's very violent and bloody. After that, there's an amendment to the Constitution, the 14th, in 1868, I believe, and it has the language, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside." That is a direct superseding of Dred Scott. Thank God. Okay, so here's what this executive order does. Two circumstances in which they are not subject to the jurisdiction thereof, therefore they are not given that protection of the 14th Amendment to become automatic citizens. One, when that person's mother was unlawfully present in the United States and the father was not a U.S. citizen or lawful permanent resident at said person's time of birth. Two, when that person's mother's presence in the United States at the time of said person's birth was lawful, but temporary, such as, but not limited to, visiting the United States under the auspices of the Visa Waiver Program or visiting on a student, work, or tourist visa, and the father was not a citizen or lawful permanent resident at the time of the person's birth. Okay, so then, we're off to the races. You have a whole bunch of states that sue, and you have some associations that sue that represent or have as members undocumented people residing in the country. All of them get nationwide injunctions. This is basically going to be about 3 nationwide injunctions. And sort of by definition, those universal/nationwide injunctions cover states that weren't part of the lawsuit and all the people, right? Regardless of whether you're a member of CASA, for instance. So the United States goes to the Supreme Court. This is back when Sarah Harris was acting Attorney General, and says this exceeds the jurisdiction under Article 3 of federal courts. You simply cannot decide a case on behalf of people who were not injured or interested parties of any kind. Therefore, you need to take this and limit the jurisdiction of these injunctions to only the states that were parties and only the associational groups. And by the way, side eye on those associational groups too. Maybe they don't have standing either. So we've got, I'm going to call 2 buckets, and one bucket has 2 issues. So bucket 1, believe it or not, is this universal injunction, nationwide injunction bucket. Within that bucket, I think you have both the scope of relief question and the associational interest question of these groups that come in to sue and say, well, we have members across the country, therefore it has to be nationwide anyway. We're an association. Thanks. So that's bucket number 1, is sort of this like non-merits. What do you do when a president has a big executive order like this? Bucket number 2 is the birthright citizenship question itself. Nobody knows whether we're getting that bucket, but I will note that the petition, the briefs, all of them do talk about the merits. So while it may not be decided on the merits, I'll be shocked if the merits aren't mentioned at oral argument, because it goes to the relief that they're asking for. And how messy it would be if, for instance, 22 states had birthright citizenship as we've understood it for a long time, and 28 states don't, so that you have to file all sorts of paperwork to sort of prove citizenship, and a birth certificate won't be enough, for instance, to get a passport like it is now, among many, many other things. I mean, maybe the first question is, we've got to count to 5 here on any sort of outcome. Amy, the justices on that nationwide injunction and associational standing, this has come up many times to the court. You've had separate writings on it. We've never had a decision, of course, but we're not coming into this blind either. What, if you were to run down each justice, where do you sort of place everyone in sort of their beginning markers?
Well, and I want to back up for a second because, I think you've sort of said this implicitly, and I think you've said it on earlier episodes, but, part of the problem is, the Trump administration came to the Supreme Court in March, asking the justices to put these district court orders on hold. And normally when the Supreme Court, normally when somebody comes to the Supreme Court, they come with what's known as a petition for certiorari, and it has a question presented. And, when the Supreme Court grants a review, it either sort of accepts by not changing the question presented, and that's the question before the justices, or it rewrites the question presented, and like that is the indication of what the justices want to talk about. But, because it came as a request to put these orders on hold, what's known as an application for a stay, there was no question presented. And so we don't really know what the justices want to talk about. And that, they gave people the opportunity to file amicus or friend of the court briefs. But, the United States and the challengers in this case, they didn't file any more briefs. So they kind of don't really know what the justices want to talk about either. And, finally, there are a lot of amicus briefs, especially on the side supporting the Trump administration, that are just about birthright citizenship. But there's really very little discussion in the parties' briefs, because this was about the universal injunctions, about birthright citizenship. So it seems kind of like, on the one hand, one of the criteria that the court is supposed to consider when it's deciding whether or not to issue this kind of temporary relief is sort of the underlying merits. But there's the idea that they would actually weigh in on birthright citizenship when the parties don't really address it just seems kind of bizarre to me.
I have a question, Amy,
Yes.
for you as a court watcher of many, many years. Are we too close to the argument date for the court to issue some kind of clarifying order saying the parties are instructed to focus on this issue or that issue? Has the train left the station on that, or could we get an order?
They could do that if they wanted to.
Okay.
They could do that, because we're still 10 days out, so people are still.
There's plenty of time.
Plenty of time.
They've been working crazy overtime.
They have started their moots, but I think people usually do moots up until a couple days before, so they could certainly end it. And I assume that they're going to be ready to discuss birthright citizenship, but it's just a little odd that
Another thing that's weird about this, David, is that in a lot of these nationwide injunction cases, we're talking about them in the context of the Administrative Procedures Act. And the Administrative Procedures Act has language passed by Congress that at least seems to give the courts the jurisdiction to, quote, set aside regulations that were not done correctly under the Administrative Procedures Act. Well, that sure looks like you can do a nationwide injunction because you're setting aside the regulation, meaning the regulation cannot be in effect. I always thought when we did nationwide injunctions, we would start with the low-hanging fruit, as the court normally likes to do. You start with the easy, narrow stuff. In this case, an APA set-aside nationwide injunction and say, like, yeah, that's okay, but here are some examples of things we're nervous about, blah, 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 I don't know, hand ring, concurrence. But we're starting here with, like, the whole fruit tree, because this is an executive order. It's not through the APA. Now, executive order is the president at his weakest in many ways. I will also note, though, that not a single brief that I read, and I didn't read all the amici yet, but of the actual parties' briefs, none of them talk about the fact that the president was acting without Congress, if that makes sense. And so a nationwide injunction setting aside a congressional statute, I sort of think of this in a Youngstown framework, right? Nationwide injunction against a statute, the most disfavored. Nationwide injunction against a regulation. Ooh, you've got that set-aside language. That's pretty good. Nationwide injunction against an executive order that purports to do something that maybe even Congress couldn't do statutorily? That seems like the most ripe thing for a nationwide injunction, setting aside what it's about at all. So, I mean, to me, if I didn't sort of know the moment we were in and how much I think the justices are sick of these nationwide injunctions, I would think that this was the perfect vehicle to approve of nationwide injunctions. But it doesn't feel that way, I guess, because I'm not in a vacuum.
I mean, one thing I will say about this is I think it is a very messy vehicle for tackling the nationwide injunctions issue. And here's another thing I'll point out. So the justices set a deadline now passed of April 29 for the amicus briefs. They also set a deadline of April 29 for motions related to the oral argument. So the plaintiffs, the folks here who are defending the pre-Trump approach to birthright citizenship, they have moved for divided argument, meaning that we want different lawyers to present for different parties. And so there are some states here. There are 3 cases, and 2 of the cases are Trump v. State of Washington, Trump v. New Jersey. And so for the states, the New Jersey Solicitor General, Jeremy Feigenbaum, would like to speak for them. And then the motion of the plaintiffs, the challengers of the order, they would like Kelsey Corcoran to speak for the private individuals and non-governmental organizations. And here, that's the case of Trump v. CASA, which is an association or organization, not governmental, that is challenging this executive order. And the reason that they want divided argument, they say, is, look, the governmental and the private/associational parties have different interests here. And you can think about that. They have different interests with respect to universal injunctions, because sometimes the governmental respondents, they're challenging the federal government. But sometimes, so the better term I think a lot of people say is universal rather than nationwide injunctions, because sometimes you might have an issue of a statewide injunction. You have a state law, and the question is this federal court going to block that law across the entire state, or is it going to block it only as to the specific parties in the specific case before that judge? So if I'm New Jersey, say, I might be rah, universal injunctions when New Jersey is suing the federal government. But when some person comes along and sues New Jersey and wants to block a New Jersey law across the entire Garden State, I might say, whoa, I don't know about these universal injunctions. So it's a kind of a messy case for, in addition to the fact that we don't even know what the heck they want to talk about, it's also messy because the challengers to the executive order have somewhat conflicting interests. And then on the issue of standing, you may have a similar issue. The associations like CASA say, we want very liberal rules for associations to have standing and bring lawsuits. these state governments, the state governments get sued all the time by associations on both the left and the right. The Harvard Affirmative Action case, Students for Fair Admission, that's an association. They may not want liberal rules on associational standing. They may want tighter rules on associational standing. And then you have the issue of state standing, the standing of state governments to sue the federal government, the EPA, this agency, that agency. So maybe on the bright side, you could think of this as, look, it's kind of like a salad bar or a Vegas buffet, and the justices can kind of choose what they want this case to be about. But if I'm the advocate, I'm like, I have no idea how to prepare for this.
So this is why on May 15th, we're going to have our extended universe extravaganza. This will age some listeners, and this is a bright dividing line, I think. So we are going to do Mystery Science Theater 3000 for the oral argument. And if you don't know what that is, then you're young. And if you also don't know what that is, then you might also be very old. But if you know what it is, you're exactly David Latney's age, and you were super cool as a teenager, basically. By cool, I mean you weren't going to parties at all. So what that means is that we'll have the live blog because it also happens to be an opinion hand down day. You've got to be kidding me. So the live blog will start nice and early. We'll get the opinions that are being handed down that day, do a brief little discussion of those. Then the oral argument will start, in which case Amy scurries into the courtroom to hear the oral argument.
Like a rat.
And then the rest of us will be listening to the live audio feed and typing in our thoughts as they go. Those thoughts will be substantive, and because Amy will not be able to monitor us, they will also be funny.
Funny?
Yeah.
I'm so
Amy,
disappointed.
I've never seen you be funny on the live blog. I think you take the responsibility that you have very seriously, and I actually very much appreciate that about you. You're offended. So then once that argument is done, however long it takes, they've said that it will be an hour. It will not be an hour. Like, lol, if this is under 2 hours, I will be impressed. Yeah. I think it will be a little bit over 2 hours is my guess now that they've done divided argument. So we have 3 people coming up.
3 lawyers, yeah.
Yeah.
No.
2 hours seems, that's your over-under at least. So we'll live blog during that whole thing, Mystery MST 3000 style. Then after that, Amy will run victorious out of the courtroom and join us for a live video AO to talk about what we learned. And that will be substantive and probably not all that funny because there'll be a lot to talk about.
Apparently.
Amy the buzzkill finally coming back. I consider you the adult in the room, Amy.
Well, unfortunately, that's often true, just by default.
Thank you guys so much for joining me today and replacing the inimitable David French, who is, as I said, off in New York City somewhere, like, small town boy in the big city. Who knows whether he'll get lost.
It's like sitcom.
Right. But don't worry, David French will be back for our next episode, and we will be talking about May 15th many more times. I think we'll get more briefs. We'll have to at some point go through those amicus. Do y'all say amici?
Amicus is how Justice Breyer used to say it, I
Dear
think.
God, that's violence.
I think there've been articles written about this.
Oh, well, there's the whole thing about how each of the justices pronounce certiorari too.
Right.
And what's weird is that I think I switch in and out of various pronunciations. I'll say amici.
This is why I just translated into English. Friend of the court. Review.
So with that, plenty more to talk about, including on the substance, the birthright citizenship issue itself, and everything in between. So more to come on Advisory Opinions.